Your first role is lawyer for the organization, and you represent them for a few years, and they say, you've done great work, you've been a great friend to the organization, you've written off a bunch of your bills. We'd like to invite you to sit on the board of directors. Under those circumstances, you really need to get that conflict waiver. And under those circumstances, I think it's important to consider that to be an explicit conflict waiver, because all conflicts analysis is forward-looking, meaning you're looking down the road and you're saying, is there a significant risk of a material limitation on my ability to represent the client? And by significant, as that term is used in Rule 1.7, we don't mean significance in the sense of likelihood. We mean significance in the sense of importance of the risk. So even if you would say, hey, it's not too likely that the conflicts Aviva and I just talked about, giving two examples, would arise, nonetheless, it's incumbent on the lawyer to explain that in writing to the client and to get their consent to it. Because what you're really telling the organization that you already represent as a client, and they ask you to come on as a board of director, what you're doing, client, is you're asking me to assume a different set of duties, a different role vis-a-vis the organization, and that's going to pose a real likelihood of limiting the ways that I can act as your lawyer in the future. Now, I may reasonably think that it's not going to be a huge problem or insurmountable problem, but you, the client, have a right to know about that before you decide to say, yes, we affirmatively want you to perform these dual roles.
And because it's an advanced waiver, one of the reasons it's so important for it to be in writing and it to be detailed, because it is an advanced waiver. And we know that under 1.7, those advanced waivers are looked at rather carefully.
Yes, that's correct. And also, you know, under that sort of different scenario where you don't transition from being a director to being a quasi-informal lawyer, right? If you have formally been engaged to represent the nonprofit entity, the most important thing for that entity might be preserving your ability to act as their lawyer. You might be their go-to person that they want available to them when they need. So it's really important that the entity, in a decision in which you don't participate, decides whether or not they want to take that risk.